Companies Act, Section 163, option to adopt the principle of proportional representation for appointment of directors. Section 163 of the Companies Act introduces an alternative method for appointing directors in a company, namely, the principle of proportional representation. This provision allows companies, through their articles of association, to adopt a more democratic system for director appointments, ensuring that minority shareholders also have a say in the composition of the board. The primary objectives of this section are to provide fair representation to different groups of shareholders, promote inclusive corporate governance by allowing diverse stakeholder interests to be reflected in board appointments, ensure minority shareholders have a voice in decision-making. This section gives companies flexibility in choosing their preferred voting mechanism, provided that at least two-thirds of the total number of directors are appointed through proportional representation. 1. The concept of proportional representation in board appointments. A. Override of general appointment rules. Section 163 begins with a non-obstant clause, notwithstanding anything contained in this Act, meaning that it takes precedence over other provisions related to the appointment of directors. While the standard rule under the Companies Act requires directors to be appointed through ordinary or special resolutions, this section permits an alternative mechanism, if specified in the company's Articles of Association. B. Mandatory minimum appointment through proportional representation. If a company chooses to adopt proportional representation, at least two-thirds of its directors must be appointed using this method. The remaining one-third of directors may be appointed through standard procedures, unless the articles specify otherwise. C. Voting systems for proportional representation. Companies may choose any of the following voting methods to implement proportional representation. 1. Single transferable vote, STV. Shareholders rank their preferred candidates in order. Votes are distributed based on preferences until the required number of directors is elected. Ensures that minority shareholders can elect at least some representatives on the board. 2. Cumulative voting system. Shareholders receive votes equal to the number of directors to be elected, which they can allocate as they wish. They may concentrate all votes on a single candidate or distribute them among multiple candidates. This system helps ensure that minority shareholders can influence the election of some directors even if they do not hold a majority of shares. 3. Other methods. The company may specify alternative proportional representation mechanisms in its articles, provided they align with the objective of ensuring fair representation for all shareholders. 2. Timing and frequency of appointments. A. 3-year appointment cycle. Directors elected through proportional representation may be appointed once every 3 years. This provides stability and continuity in board composition while still allowing periodic changes. B. Implications of the 3-year term. Unlike the annual appointment process for some directors under standard rules, proportional representation appointments last for 3 years, unless specified otherwise. This longer term reduces the frequency of elections, ensuring strategic stability in corporate governance. 3. Filling casual vacancies for directors appointed via proportional representation. A. Application of Section 161(4). If a director appointed under the proportional representation system vacates their position before completing their term, their replacement must be appointed in accordance with Section 161(4) of the Companies Act. This means that the Board of Directors may appoint a replacement, subject to approval at the next general meeting. The replacement director holds office only for the remaining term of the original director. The method of appointment must be consistent with the original proportional representation system used. B. Preventing disruption in governance. By specifying how vacancies should be filled, Section 163 ensures that board representation remains consistent, even if a director leaves before completing their term. It prevents arbitrary appointments that could undermine the proportional representation structure. 4. Benefits and rationale behind proportional representation. Ensures minority representation, prevents majority shareholders from exclusively controlling board composition. Promotes fairness in corporate governance, allows diverse shareholder groups to participate in decision-making. Encourages long-term strategic planning. 3-year director terms provide stability in governance. Provides flexibility to companies, allows firms to choose a voting method that suits their structure and shareholders. Prevents undue board control shifts, requires casual vacancies to be filled through the same system, ensuring continuity. 5. Compliance considerations for companies. A. Amending Articles of Association. Companies wishing to adopt proportional representation must include provisions in their Articles of Association. If the articles do not contain such provisions, directors must be appointed through standard rules under Section 152 of the Companies Act. B. Consistency in voting mechanism. Once a company adopts a specific proportional representation method, it must apply the same system for all elections under this rule. Any changes to the system require an amendment to the Articles of Association, which must be approved by shareholders. C. Regulatory compliance. Companies using proportional representation must ensure compliance with all applicable provisions of the Companies Act, particularly those related to director eligibility and qualifications. Restrictions on the number of directorships a person can hold. Disclosure requirements for directors. For more details, contact us.